Hey, folks, welcome to today's episode of The Law of Self-Defense. Slight delayed start. Something popped up at the last second, but that's taken care of. And so here we are. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you. Thank you so much. Come on in, make yourselves comfortable. Today, we're going to talk about the fact that appeals are for losers in the specific context of the oral argument made on appeal to the Minnesota Court of Appeals by legal counsel for Derek Chauvin. Derek Chauvin, of course, the police officer who was convicted for the death of George Floyd in Minneapolis, in a trial we covered, of course, very, very closely. And I'll do a quick review of the case, the facts of the case, why this was an unjust conviction, really just a political persecution, but also why Derek Chauvin is very, very unlikely to get any kind of substantial relief through the process of these appeals for a variety of reasons. And then we'll watch the actual video of the oral arguments. It's not all that long. We'll hear from Derek Chauvin's appellate counsel and also from the state of Minnesota, which obviously is arguing against any kind of relief for Chauvin on appeal. So before we jump into that, a quick reminder that today's show is sponsored by none other than the Law of Self-Defense itself, specifically our upcoming Law of Self-Defense Advanced class. This is our full-day class on self-defense law, taught live by me via Zoom. We teach this class once, sometimes twice a year. We're only promising once for 2023, and that class is Saturday, April 15th. The best part is if you sign up for that class before the end of the month, within the month of January, you get 50% off the normal registration. That saves you $100. If you put off signing up until February, it's only 25% off. March is only 10% off. April is simply full price. So sign up early to save the most dinero. You can learn more about the specifics of what we cover in that class. It's really everything, folks. It's a full day class version of this, but of course continuously updated with real world examples to make sure that you most effectively capture a substantive understanding of the legal boundaries for the use of self-defense, so that if you're ever compelled to use force in defense of yourself, your family, your property, you're also hard to convict, not because you learned any legal tricks. We don't teach legal tricks, but because you knew where the actual legal boundaries really are, as opposed to what the internet might teach you they are. You can learn more about that class, what we cover, and register at lawofselfdefense.com/advanced. Also, as always, if you'd like to ask questions at any time during today's show, there's two ways to do it. The most effective way to do it is to become a Law of Self-Defense member. Watch the show in the member chat. Let me take a quick look. Yep, it is streaming there. Members can ask as many questions in the member chat as they like, and I will answer them all. It's helpful if you do that to preface your question with the word question in all capitals, so it's easy for me to find. And you can become a member if you're not a member yet. It's very easy. It's less than $10 a month to be a Law of Self-Defense member, only about 30 cents a day. You can join right now and ask an infinite number of use of force law questions over at the member dashboard. You can join right now by pointing your browser to lawofselfdefense.com/join. Easy enough to do. The other way to submit questions is to make them be super chats. We will accept super chat questions. The super chat needs to be at least $5, folks. $5 super chats, and I'll periodically take a look and see what has been going on with the super chats as they come in and answer those questions as well. Obviously, it's a lot more cost effective to be a Law of Self-Defense member for $10, less than $10 for an entire month of free questions than it is to be paying $5 a question to YouTube on super chats, but I leave that decision up to your discretion. So let's take a quick reminder of what happened with Derek Chauvin and George Floyd. So I'm just going to give a quick summary from my recollection of the facts. If I make small errors around the margins, it's not important for our purposes today. I wrote thousands of words of legal analysis and commentary on this trial as it was taking place. So I refer you all back to that if you want every incremental piece of detail about the case. I'm just going to give a quick overview. So George Floyd had gone into a convenience store in Minnesota and tried to buy something with counterfeit money. The clerks didn't appreciate that. They called the police. The police responded. George Floyd was sitting in his vehicle outside the convenience store. They approached him and they went to make an arrest for Floyd's use of fake money. George was non-compliant with arrest. He forcibly resisted arrest, quite forcefully. He's a very large gentleman. And in the course of all this, he had apparently ingested a whole bunch of illicit drugs that he had with him. There was broken tablets, capsules around his mouth, inside the vehicle. He would be found later to have had a tox levels of 3 times a fatal dose of fentanyl in his system. He had a pre-existing heart disease. He fought the police, forcibly fought 4 officers for something like 10 minutes. They finally got him on the ground beside his vehicle and held him there. They called for ambulance, for EMS to come, and they held him there waiting for EMS. A crowd had gathered by this point on the sidewalk. 10 or 15 people were now observing the struggle and this arrest in progress. George Floyd had repeatedly said he was having difficulty breathing, even when he was standing up, even when he was inside his vehicle fighting with police, and he continued that on the ground, continually speaking on the ground until the last perhaps 3 minutes before EMS showed up. He was being restrained in a manner that is consistent with police training for excited delirium. There was concern that Floyd was experiencing excited delirium. That's a condition in which typically a person on illicit drugs goes into a psychiatric state where they become extremely violent, and they will fight anybody to the point where the level of effort they're actually putting into the fight causes them injury. So the training for this is, if you're dealing with a suspect you suspect you believe may be experiencing exciting delirium, is to immobilize them. Use multiple officers along the length of their body to hold them on the ground so they're not overexerting themselves. That's essentially what the officers were doing here. Derek Chauvin, for a large part of this period on the ground, had his knee characterized as on Floyd's neck. That's not really true. If you watch the video, it's mostly between Floyd's shoulder blades, as opposed to the claim that he was compressing Floyd's neck for 9 minutes. That's just nonsense. In any case, Floyd was talking for almost this entire time on the ground, arguably until about 3 minutes before EMS showed up. About a minute and a half before EMS showed up, one of the officers checked George Floyd's pulse. He may not have had a pulse at that point, but in any case, that information was never communicated to Derek Chauvin. And George Floyd would, of course, die. And Chauvin would be criminally charged. Now, he was charged with several crimes, and these crimes are listed in Minnesota law as murder. So, and of course, Derek Chauvin was convicted of these crimes. I'll go into the details of the crimes in a moment. But it's important to know that these crimes were not murder in the technical sense. They're labeled murder as an oddity of Minnesota law. Now, traditionally, murder is an intentional killing. We call that murder. An unintentional killing is typically not murder. It might be an unlawful killing. It might be manslaughter. It might be involuntary manslaughter. But it's not murder unless it's intentional. That's how these concepts are taught in law school. That's their normal understanding. That's how they're typically framed in most unlawful killing statutes across the country. It's murder if there's intent to kill. It's something less than murder. We don't call it murder if there's no intent to kill, but we might call it something else if it's an other form of unlawful killing lacking intent, like involuntary manslaughter, reckless manslaughter, for example. But Minnesota, for whatever reason, labels what would normally be called involuntary manslaughter as a form of murder. So the media then is free to report that Chauvin was charged with murder and convicted of murder. And it kind of skates over the reality that no one ever in this case, not even the prosecution, ever argued that Chauvin intentionally killed George Floyd. So there was never a claim of intentional killing here. There was essentially Chauvin was convicted of 3 counts of unlawful killing. One of them was felony murder, with the underlying felony being aggravated assault, that his use of force upon Floyd was not justified and was capable of causing serious death or injury, but still no intent to kill. Another was essentially, the other counts were essentially involuntary manslaughter, that he created a reckless risk of death or serious bodily injury, and the death resulted. On the legal merits, I don't see how either of those, any of those charges could really be proven beyond a reasonable doubt, given that there are reasonable hypotheses for Floyd's death that have nothing to do with Derek Chauvin's use of force on him. By the way, all the other officers were also convicted in this case in state court, and then either convicted or pled guilty to charges at the federal level as well. But on the legal merits, none of these officers should have been convicted of these crimes, particularly not, especially or notably not Derek Chauvin, the first one who was convicted. Because there are reasonable hypotheses for Floyd's death that have nothing to do with the officer's conduct. Specifically, Floyd's 3 times fatal levels of fentanyl in his blood at the time of his death, as well as his pre-existing heart condition, the fact that he'd fought lawful arrest for 10 minutes before he was ever on the ground and subjected to any kind of purported force that might constrain his breathing. So any of those things could have killed Floyd. And if you have a reasonable hypothesis for Floyd's death that's inconsistent with guilt, you don't have guilt beyond a reasonable doubt. But of course, this had become a political prosecution. Police bad, black man killed, resisting arrest. So they have to be convicted. We know that jurors snuck on to the jury, lying during voir dire about their participation in rallies and so forth around this event. And we know that there was unbelievable security around the courthouse, including concrete barriers, barbed wire, police armed with machine guns, armored vehicles. And the jurors saw all this every day going in and out of the courtroom. And there were very public and widespread statements that there would be riots, arson, looting, chaos if Derek Chauvin was not convicted. And of course, the jurors knew all this too. They had special security measures for the jurors. At one point, they were followed by media back to their transportation spot, where they were basically shuttled into and out of the courtroom. And all the jurors also know that eventually their identities would be made public. So if they acquitted Derek Chauvin, the whole world would know who they were. And of course, an acquittal has to be unanimous. That each and every one of them voted not to convict Derek Chauvin. So a very, very toxic, politicized, racially energized case in which a conviction on the charges seems likely completely absent any legal merit or actual application of law. And of course, that's exactly what we saw. Now, Derek Chauvin is appealing these convictions in Minnesota to the Minnesota Court of Appeals. This would be the mid-level appellate courts in Minnesota. So you have the trial courts where he was convicted. You have the mid-level appellate courts. Typically, that would be a 3-justice panel or a 3-judge panel at the mid-level, and they would vote collectively in either 3-0, 2-1 kind of vote at the end on whatever decision they came down with. And an appeal from the Court of Appeals would, of course, go to the Minnesota Supreme Court. I don't know how many members are on the Minnesota Supreme Court. I didn't bother looking, but it's typically 5 or 7 or 9, some odd number, so that you don't end up with tie votes. And here's the problem with appeals, and why you probably have heard me say quite often that appeals are for losers. There's often a sense that An appeal is kind of like a do-over of a trial. Well, if he gets convicted, he can always appeal that particular issue, whatever the case may be. It is far, far from a do-over, folks. When you're at trial, all the legal presumptions are in your favor. You're presumed innocent until proven guilty beyond a reasonable doubt. But once you're convicted, that all flips. Once you're convicted at trial, you're presumed guilty. And all the presumptions go against you. The presumption is that the outcome of the trial was the right outcome. And the appellate courts don't want to do the job of the trial courts. They're not going to completely revisit a trial. There's a tension here, right, between wanting whatever we think justice is from a trial process, but also a need for finality, that we got an answer and that's the answer we're going with, that we're not going to do, best of 5 trials. We're not going to do World Series type criminal trials. You get one trial, and whatever the verdict is, we're inclined to stick with that and not just do it over and over again because you didn't like the result. It's more like a Super Bowl environment than a World Series environment. And the appellate courts, especially in the last few decades, they've become much more bound to concerns about finality. This is done. You had a trial. It's over. And they don't want to be trial judges. Also, of course, the appellate courts don't hear actual evidence. They don't see witnesses testify. They can't evaluate the credibility, the demeanor of witnesses as they're testifying. The trial judge can. The jury can. So especially when it comes to findings of fact, what testimony, what evidence you believe has the greater weight, was credible, was compelling, the appellate courts don't like to touch findings of fact because they don't have direct access to that evidence. They never saw the testimony. They are more amenable to errors in findings of law, legal decisions that were made by the judge. They'll take a look at those, maybe, but only if certain conditions are met. And again, they don't just want to routinely second guess every legal decision made by a trial judge. They're appellate court judges. They're at a higher level. They probably were previously trial judges. That's not their job anymore. They want to leave the trial judge job up to the trial judge. And they give that trial judge enormous discretion in making the decisions that need to be made in a courtroom. Necessarily so. Otherwise, why would you have the trial judge in the first place? If you weren't going to allow him to make the calls and not simply be second guessed on appeal. So generally there are 3 things that have to happen before you can have any hope of a claimed error at trial being an appealable issue. By the way, when you do get to appeal and you win on appeal, generally all that means is that you get to do the trial over again. That the appellate court says, yes, this was a sufficiently substantial error at trial that we can't trust the verdict, and therefore we're going to remand you for retrial. I mean, that's a win. You're not convicted anymore, but you're just going through the trial process again. The appellate courts virtually never will reverse a conviction with prejudice, meaning we're saying you're not guilty ourselves, so you can't be retried again. Never happens. Indeed, getting remanded for a new trial, the main win you can hope for on appeal. Attorney Steve Gosney, frequently on the show, he did an analysis of this for the Florida courts, and it's pretty representative, I think, based on my reading of thousands of appellate court decisions, that less than 1% of appeals result in a new trial. Those are not good odds, folks. And you go to the new trial, that doesn't mean you're not going to get convicted in the new trial. It just means that particular error won't be made again because the appellate courts have pointed out where the error was. And by the way, you're usually going back to the same judge you had in your first trial. That's standard practice because he's already familiar with all the arguments and motions and so forth. You'll get a new jury for a retrial, but generally you have the same judge. So that judge has been told by the Court of Appeals, hey, you made a mistake here. You made a legal mistake in a ruling. Don't do that again. Do a new trial, and this is how we want you to rule on that particular issue. But that doesn't mean you're going to win on retrial. You could just get convicted again. Less than 1% of the time do you get remanded for a new trial, and even then, that doesn't mean you're going to be found not guilty. So that's why appeals are for losers. the chances of getting any kind of relief are infinitesimal. And the relief is just another trial. So you go through the whole process again. And by the way, most people don't have any money for a second trial. If they were lucky enough to be able to afford a vigorous defense in their first trial, well, what percentage of your assets do you spend to try to avoid getting convicted and going to prison? Probably most of what you have. And if you expend all that in the first trial, what do you think you have left for a second trial? Nothing. So not uncommon to see defendants go through a first trial, have a very expensive, high-paid legal team for their defense, get convicted, win on appeal, get remanded for a second trial, and have a public defender for the second trial because they don't have any money left. So appeals are for losers. So what do you need to have any hope in an appeal? To have an issue that might reverse a conviction and get you a new trial? Well, first you have to have some kind of claimed error, right? That was done wrong. The judge made an incorrect ruling of law. Then you have to preserve the error. Or in rare cases, the error needs to be so substantial, so fundamental that it's kind of self-preserving. I'll come back to that in a moment. But normally, claimed errors need to be preserved by objection. Your lawyer has to object. If your lawyer doesn't object, it's not preserved for appeal. The appellate court won't even look at it. This was a big problem in the recent Aaron Dean conviction because lots of errors were made, I would argue, in that trial. But the defense didn't object to most of them. So they're not preserved for appeal. And the reason the appellate courts demand that the error be preserved for appeal, typically by objection, is because they want the issue, whatever the claimed error is, that they want it first to be argued in court. So the trial judge has a chance to fix the error right there. They don't want, like, the defense to be able to say, oh, that was an error, but I'm not going to mention it. I'm going to save that for appeal. No, you can't do that. You have to give the trial judge an opportunity to fix the mistake right then by objecting. Well, if you object and the judge says, no, I'm still doing it this way, well, then you've preserved that error for appeal. But sometimes the judge says, oh, you're right. That's not the way it should be done. And he fixes the error. Then you don't have to worry about it because you got your way. But you do have to preserve the claimed error by objection. Or there are a very few cases where the error is so fundamental, like it touches on a fundamental constitutional right, for example, that even if the defense lawyers don't object, the appellate court might still look at it because it goes to the very core of justice. But those are very, very rare. Generally speaking, if there's an error and your lawyer didn't recognize it, didn't object, or for strategic reasons didn't object, it's not preserved. And sometimes, folks, you'll see defense lawyers do like a running objection. There's a line of questioning that the state is engaging a witness with, and the defense objects to that line of question. They say it's hearsay, for example. So it normally should not be admissible. And the judge says, no, I'll allow it. But it's a whole bunch of questions, and the defense attorney doesn't want to object to every question because it becomes repetitive and disruptive and irritates the judge and probably irritates the jury, especially when it's become obvious that the judge is going to overrule every objection, because they're all similar. They're all essentially the same objection over and over again. And the defense lawyer might say, to avoid that repetitive objection, say, Your Honor, I just like a running objection, meaning I'm letting you know up front I'm objecting to this whole line of questioning on the same grounds. And the judge will say, yeah, okay, that's fine. But when it gets to the appellate courts, they don't like running objections. They want to know exactly, specifically what you're objecting to and why, so that they can do their own analysis on appeal of whether or not they think your argument has legal merit. Running objections become too vague and too ambiguous for the appellate courts. It's too much work. They don't want to have to imagine the 50 different reasons why you might be objecting to something in court. They want you to specify it. So there has to be a claimed error of some kind. You have to have preserved it for appeal, or it needs to be self-preserving. And finally, it has to have made a difference. The outcome would have been different but for the error. Most errors made a trial, even when the appellate courts agree it was an error, it was a legitimate error, and it was preserved by objection. It was harmless error because the verdict would have been the same regardless. And an example of this might be, you might have, say, 10 pieces of forensic evidence that were submitted, 10 photographs of a crime scene, all of which were consistent with guilt. and one of them is somehow defective, and you object to that one photograph, you said that should not be admitted. You object, so you preserve it for objection. The judge allows it anyway, and the appellate court says, yeah, that one photo, that shouldn't have been shown to the jury. But the other 9, the weight of evidence was so overwhelmingly in favor of guilt, regardless, that one error doesn't change the outcome. It's harmless error. So you need the claimed error. You need to have preserved it for appeal, and it needs to have mattered. It wasn't just harmless error. So that's generally what we're looking at. And to the extent that the trial counsel had an opportunity to argue the issue before the judge, and of course the state would have argued their side of whatever the issue is, and the judge made a decision, the appellate courts are overwhelmingly going to defer to the trial judge's decision. If it could have gone either way, a reasonable judge could have decided either way. That's why we have trial judges, to make those calls. The appellate court won't reverse based on a judge's decision unless it's what is referred to as an abuse of discretion. And all that's just a fancy phrase for saying, all right, in that case, we think it was a bad enough decision that we should reverse on it. That's all that really means. But generally what they're looking for is a completely irrational decision or an unambiguous error. So say, for example, a conviction would require that the defendant had killed multiple people, some kind of aggravated form of murder. But there's only ever evidence of one person being killed. Well, just on the facts, that law can't apply in that context. Rationally, it can't apply. That kind of error is something that the appellate courts would likely view as an abuse of discretion. But if it's just a judgment call by the trial judge, that's what trial judges are for. Too bad you didn't like the judgment call. The appellate court may not even like the judgment call, but they don't have to like it. They just recognize that it's the trial judge's job to make that call. So all of these contribute to why it's so difficult to win on appeal. And again, when you win, all you really get is a new trial. Lots of appealable issues, I guess, in the trial of Derek Chauvin. The trouble is, most of them were argued out at trial. The judge made those calls. The trial judge made those calls. And I haven't watched this video, the oral argument on appeal, but I expect most of what we're going to hear from these court of appeal judges is, well, didn't you talk about that at trial? Because if you didn't talk about it at trial, it's almost certainly not preserved for appeal on that basis. If you did talk about a trial, why should we upset the trial judge's call on that? It feels like a catch-22, right? So that's what I expect we'll see as we go through this video. It's about 40 minutes long, 45 minutes long of the oral arguments. So that's what I expect to happen during the defense oral argument. I think the state is just going to say, listen, we had a trial. The jury decided that there's no reason to upset this verdict. And ultimately, I think that's what the Court of Appeals will decide. Even not having watched the oral arguments, that would be my prediction, because that's what happens 99% of the time. So, and even worse here, of course, is this is a hyper politicized case. So the legal merits, the evidentiary merits hardly matter here. Derek Chauvin is Satan. He had to be convicted. George Floyd's a saint. And he was just, he was murdered, even though we know, technically speaking, nobody ever claimed an intentional killing here. Not even the state claimed an intentional killing. So that's where we are. So in that political dynamic, look, all these Court of Appeal judges, the 3-judge panel we're going to see here, you think they don't want to have a chance to be on the Supreme Court of Minnesota? You think there's any possibility they could get to the Supreme Court of Minnesota if they were to allow this conviction to be reversed? Should that play a role in their decision-making? Of course not. Political self-interest? No, justice is supposed to be blind, right? But the justice system is not a magic box where you put law and facts on one side, crank a handle, and get perfect justice out the other side. That box is full of people with their own motivations, desires, passions, biases. And that includes appellate court judges. All right, so let me take a quick look and see if any questions have come in already. And then I'll hop over to the actual video. Law of Self-Defense member, I'll do the members first. Law of Self-Defense member Kyle says, I think I've gotten in about $80 worth of questions in the last 3 weeks. Yeah, maybe. And that's fine. That's what being a Law of Self-Defense member gets you. and you can become a law self-defense member. Ask as many questions as you want in the member chat for free. Less than $10 a month, 30 cents a day to be a law self-defense member at lawofselfdefense.com/join. Let's see. So inadequate counsel, ineffective assistance of counsel would be the constitutionally relevant phrase. You have a constitutional right to effective counsel. So if your counsel is ineffective, that's an appealable issue. And it goes to constitutional merit. And it's not an issue that your lawyer is required to preserve on appeal, because naturally, if your lawyer is ineffective, he's not going to preserve his own ineffectiveness by objecting and preserving the issue by objection at trial. Right. So that is one of the grounds you can appeal on without it having been preserved at trial. The difficulty with ineffective assistance of counsel, and I don't think the counsel there was ineffective. I think he got tired by the end, and he was fighting against 9, 10, 12 prosecutors on the other side who were filing motions day and night that he had to respond to, but besides being in court all day. I think he got tired near the end, but I think he was largely effective. I just think there was nothing he could do. The politics, the energy around the case made it impossible to get a fair trial for his client, especially when they wouldn't change venue. He objected all the time to, just the appearance of the courtroom. It would look like a bunker in World War II. All the protests outside, everything, crazy situation. But I think the defense lawyer did a reasonably good job in that trial. But to claim ineffective assistance of counsel, the standard for what makes counsel effective is so low that it's almost impossible to prove ineffective. There's cases where the defense lawyer falls asleep during testimony and he's not deemed to be ineffective. Now, why might that be? Well, maybe the testimony that was being given was pointless. So it doesn't matter that he wasn't listening to it. Often lawyers are making strategic decisions about what arguments they want to make, what points of law, what objections they want to make, what evidence they want to pull from a witness, what witnesses they want to call to testify. Lawyers are making lots of strategic decisions. They have limited resources. They have to choose between various alternatives. And of course, every defendant who gets convicted, who loses a trial, they want to believe they got convicted because their defense lawyer screwed up. So it's one of the most common claims on appeal you see. You see it all the time, ineffective assistance of counsel, but it almost never works because the threshold for what's necessary for effective is pretty low. And the fact that a lawyer didn't make this argument or didn't call that witness, the appellate courts generally say, well, that's just strategic decision-making. That wasn't an error. That was just a choice made by the lawyer. So ineffective assistance of counsel almost never works. You only see it work in situations where, say, a self-defense case, where the only possible legal defense is self-defense. And for some reason, the defense lawyer chooses not to argue self-defense. Maybe he chooses instead to argue alibi defense, like, you got the wrong guy. Whoever did this killing, it wasn't my client. My client was at his mother's house having dinner. The evidence can be so egregious that the alibi can't work, that the only real defense is self-defense, and the lawyer chooses not to argue self-defense. Sometimes the appellate courts will say, yeah, that was just ineffective. But it's so rare, it's hardly ever worth pointing in. Okay, and let me take a look now at the super chat, see if any have come in so far. It has to be $5 minimum super chat, folks. All right, nothing there. So let me pull up this video here. And we'll see. I believe we start, because this would be a motion by the Chauvin team. We'll hear argument in favor of the motion of the appeal by Chauvin's appellate lawyer, who's different than his trial lawyer. By the way, you almost always have a different appellate lawyer than you do a trial lawyer for a number of reasons. One is it's a very different skill set to be an appellate lawyer than a trial lawyer. A lot of being a trial lawyer is theater. Right? And you have a jury there, and you're appealing to the emotions, the passions of the jury. Even though the jury is supposed to not do that, of course, you're playing a role in front of the jury, this naive audience. And there's a very dynamic nature of the trial with witnesses testifying and you're objecting and you're cross-examining. None of that happens in appellate court. Appellate court is, there is no jury. You're arguing to legal professionals, these appellate court judges. It tends to be very technical, lots of legal research, fine details of argument that you just don't really see in a courtroom trial. So very different skill set. Also, of course, one of the things you always want to be able to have in your quiver to argue on appeal is that ineffective assistance of counsel, that you got convicted because your trial lawyer sucked. That's a hard argument to make if you're keeping that same lawyer for your appeal. So generally speaking, it's very, very unusual to see the trial lawyer still involved at the appellate level. The only time you'll generally see a trial lawyer involved at the appellate level often is can be as a witness if it is an ineffective assistance of counsel claim. Because sometimes the appellate courts are like, well, it might have been ineffective assistance. Let's call in the trial lawyer, have him speak to us and explain, was this a strategic decision or was he inept? That happens sometimes, but pretty unusual. Okay, so let's pull up this video here. I guess I'll get my crank up for the audio. Let's see, volume extension. And that should work.
2023. We have 6 cases on our calendar today.
Oh, this hearing took place last Wednesday, folks. Was that the 18th? I think it was the 18th. Today's the 25th. It would have been the 18th for sure. So this Judge Reyes just read out the date. That's all.
4 are set for oral argument. The first of which is A21-1228, State of Minnesota versus Derek Michael Chauvin. Counsel for appellant is seated to my left here. You will have 15 minutes for your initial arguments, and counsel for responding, you'll have 15 minutes for your arguments. Counsel for appellant, you will have 5 minutes after that for rebuttal if you so choose.
So at the trial level, of course, we have the state versus the defendant. The defendant here being Derek Chauvin at trial. Now that he's convicted, he's on appeal. He's no longer referred to as the defendant. Now he's the appellant. He's appealing his conviction, and the state now becomes the respondent. So it's appellant versus respondent as opposed to state versus defendant at trial.
We have the podium in the middle. There is a button on the lower part to lower and raise the podium. And you can also adjust the microphone. There is a timer there. Please be mindful of the amount of time that you have to stay within your time limits. We are allowing this to be live streamed and to be recorded.
So yeah, this is a mid-level appellate court. Again, trial court, mid-level appellate court, state Supreme Court. That's the structure most states use. There are a couple states that don't have a mid-level appellate court because their population is so low. I think Montana is one of those. So in Montana, you just have the trial court and then the state Supreme Court. But most states have a trial court, mid-level appellate court, and state Supreme Court. Mid-level appellate court's typically a 3-judge panel. And then the state Supreme Court would be the next level. On rare occasions, you might see a mid-level appellate court 3-judge panel render a ruling. And then that's, instead of being appealed to the state Supreme Court, it might be heard en banc by the entire appellate court system. This is more common at the federal level. So when I say they have a mid-level appellate court with 3 judges, there's usually a lot of mid-level appellate courts in a state. And there's a whole bunch of appellate court judges, and they're randomly assigned 3 at a time to hear a case, to hear an appeal. But there may be 12 of them in the whole state. And sometimes they'll hear an appeal from a 3-judge panel. They'll rehear it en banc. So all 12 of them will sit. Again, that's more common at the federal level. You see that a lot in places like the Ninth Circuit in federal court, where you may occasionally get a 3-judge panel that delivers a pro-Second Amendment ruling. And then because the totality of the Ninth Circuit appellate court judges are anti-Second Amendment, they'll rehear it because they don't like the outcome of the 3-judge panel. And they'll reverse it en banc.
However, no other recordings are allowed, and we will be recording the audio version of this hearing as well. That will be available within a few days for council. Also, council, when you approach the podium, please state your name for the record and your party you're representing. Will any party be splitting any time within any other council at all? Yes, will council for either party be splitting time with anyone else? Okay, thank you very much. With that, counsel for appellant, you may approach the podium and begin your arguments.
Good morning, Your Honors. My name is William Mormon. I represent appellant Derek Chauvin. May it please the court, counsel. I do want to note, unfortunately, before I begin my argument, I had an oral argument before the Court of Appeals last week, and it wasn't a big problem in that courtroom, but it is here. 8 years ago, I lost my hearing in my left ear. So I've got single-sided deafness that may cause some issues hearing things. In addition, when two people are talking, and that can include myself, it all turns into a jumble. So if the court asks me a question in the middle of my argument, which is of course legitimate, I may ask you to repeat it.
Not a problem. Feel free to let us know at any time, and we'll make sure to try to speak up as loudly as possible to make sure. But please let us know if you have any issues at all.
I will, and you'll often see me when you talk tilting my head this way, and that's to direct my ear towards you. The primary issue on this appeal is whether a criminal defendant can get a fair trial consistent with constitutional requirements in a courthouse that's surrounded by concrete block, barbed wire, 2 armored personnel carriers, and a squad of National Guard troops, all of which are whom are there for one purpose: in the event that the jury acquits the defendant. I want to begin my argument today, and most of my argument today, focusing on the issue, constitutional issue of the pervasiveness of the pretrial publicity in this case, combined with a factor that's not often found in cases regarding a fair trial, and that's physical pressure on the courthouse and the courthouse participants.
Counsel, I understand that you want to address that issue, and I certainly want to discuss that one. But before we get to that issue, there's one other I wanted to talk about briefly, and that's with respect to the Schwartz hearing.
Yes.
And would you agree that with respect to jury questioning, that Chauvin had the opportunity to question all of the jurors, including Juror 52?
Yes.
Okay. Would you agree that the district...
So a Schwartz hearing, folks, is a hearing in which the trial court might explore whether or not a juror has been subject to influence. So a juror, I don't know, is bribed, or their child is kidnapped and threatened unless the juror returns a particular verdict, that kind of thing. So juror misconduct, coercion, influence, that's what the purpose of a Schwartz hearing is, to explore that. So this appellate court judge is saying, hey, I just want to know if this is going to be one of the arguments made. Let's address it right now. And really, it sounds like what his point is, what I mentioned earlier, is that if you're going to raise that now, didn't the trial court present an opportunity to do that? And if you had the opportunity to do that at the trial court, it's gone. I mean, you made that argument to the trial judge, and he made his decision.
The court has, under case law, fairly broad discretion on whether to grant or deny a request for a Schwartz hearing.
Yes.
Okay. And would you agree that case law also recognizes that a district court does not abuse its fairly broad discretion?
So the district court here is the trial court.
When a defendant has an opportunity to question a juror, even if there is a basis to hold a hearing.
That I don't agree with, because in this case, the juror answered juror questionnaires falsely that were directly relevant to the issues in the case, with ferreting out potential juror bias.
But that's a fairly accurate paraphrase from the Stofflet case, that a district court does not abuse its broad discretion when a defendant has an opportunity to question a juror, even if there is a basis to hold a hearing. In other words, we give fairly broad discretion to the district court in terms of its decisions.
That's true. I think there's an exception when you get a false question to a jury questionnaire. I mean, there were four items we pointed out in our brief. The most important one to me is the questionnaire asked whether or not the participants had attended any kind of rallies or protests related to police brutality, and juror 52 attended the rally in Washington.
I don't think rally was the word that was used in that question for the juror. I think the question was protests. Yes. And even in Chauvin's briefing below, as well as the briefing to this court, it identified and referred to that as a march, the event in Washington as a march. And there were specific questions that were asked, but in terms of protests in Minneapolis, and he answered no, which was truthful. He didn't.
That's correct.
Yeah. But the question on protests, the broad question on protests did not include the word march. And even Chauvin appeared to acknowledge that that was a march. It wasn't a protest.
I don't see in the context of this case the difference between those two items.
Well, I think it is. Your briefing seems to acknowledge that there is a difference because those two words were not used synonymously. So I don't see how that testimony is false. If
this is I mean, this is silly semantics on the part of, but this tells us all we need to know, right, about how this appeal is going to go, how this oral argument is going to go. There's no substantive difference between the terms march and protest in the context of the jury questionnaire. The point of asking the question was, are you, to search out bias, impartiality, and one indication of that is you got up and went and marched or protested on behalf of one side of this argument being made at the trial. But this appellate court judge is going to pretend that there's a substantial difference between the word march and the word protest in this context.
I think in terms of a juror questionnaire, the juror questionnaire would get quite lengthy and wordy if you had to tease out every word like that.
That's what voir dire is for, though, to be able to expand on the questionnaires and ask those probing questions. And case law is clear that the burden for asking those probing questions is on the defendant.
I understand that. I still think in the context of this case, the juror was not forthright in answering that question, yes, and acknowledging that he had attended a rally, protest, march, whatever in Washington that was directly connected to this case. I'm sorry if I...
No, go ahead.
You seem to want to ask another question on this.
No, go ahead.
Okay.
Before we leave the Schwartz hearing issue, assuming we agree that the trial court should have held a Schwartz hearing, what would you propose that we do with this appeal?
That the case be remanded to the court to hold a Schwartz hearing, and that the district court then make decisions based on the Schwartz hearing. I'm sorry, Your Honor.
How do we handle the rest of the items of your appeal? We wait until there's a Schwartz hearing, or we decide those questions and then expect a Schwartz hearing?
No, you can decide. You certainly can decide the change of venue issue without deciding the Schwartz hearing. I don't see the Schwartz hearing appeal as blocking this court from ruling on the change of venue issue at all. Have I responded to your question, Your Honor?
That's not the only item you raised in the appeal.
No.
What do we do with the rest of the issues? The question is it appropriate that we then remand the Schwartz hearing and continue this appeal, or?
I don't know if all of you, if that's audible to you folks, because this judge doesn't have his microphone turned on. But basically the judge is saying, hey, there's a whole bunch of issues you're appealing here. If you're arguing that there should have been a Schwartz hearing, if we agree with your argument, what do? Well, you send it back to the trial court for a Schwartz hearing, a hearing investigating whether there was undue influence on any of the jurors. But the appellate court judge is saying, if we agree with that, should we defer on the other issues that you're arguing? Or do we have to put in the effort? I mean, because that would make their job a lot easier, right? If we just agree with Schwartz, we don't have to address these other things at this time. But of course, the appellate court lawyer would like all the issues addressed now, so he doesn't have to come back.
Like the questions if we can, and then order Schwartz.
If the court rules in my favor, or my client's favor, on the other issues we've raised on appeal, that means there's going to have to be a new trial. At that point, I don't think we need to have a Schwartz hearing, because the main remedy my client's looking for here is a new trial.
But before you get to new trial, you have to have a Schwartz hearing first, don't you?
Not
No.
if you rule in my, I think Judge Klapiecki would.
Oh my God, is something wrong with these appellate court judges? Well, one of the other issues he's arguing is there should have been a change of venue. So the entire trial was illegitimate. So you need to remand it for a new trial. If you have a new trial, you get a new jury. If you get a new trial, it doesn't matter if the earlier jury in the first trial was under undue influence, because you're having a new trial. So it becomes a moot point. Jeepers.
Is asking me what happens with the other issues related to the Schwartz hearing. If the court concludes that the other issues that Appellant Chauvin has appealed from in this case, that he's correct in those, then the remand back to the district court is to hold a new trial, or on the change of venue issue, to remand to the district court to determine a new venue and a new trial is held. And then you don't need a Schwartz hearing. The whole purpose of a Schwartz hearing is to ferret out if the guilty verdict in the case that's before you was tainted by juror misconduct, and then to go back in a Schwartz hearing and figure that out, and then the remedy from that will be to have a new trial.
And for the Schwartz hearing, the only issue that was raised below, was the only issue with the Schwartz hearing raised below the March on Washington?
No, there were four issues related to the juror questionnaire, including, as you cited, the whether anybody attended a rally in Minneapolis, whether anyone had negative feelings about the Minneapolis Police Department, and the kind of a res gesti question at the end. Is there anything else that the court should be aware of?
Where in the record were those issues raised to the district court? It appeared that the only one that was actually raised to the district court was the one on the March on Washington.
So here the appellate court is saying, hey, if you're raising these questions with us, did you give the trial court an opportunity to address these at the time? Because if you didn't, we're not going to consider it. If you thought these things were objectionable, and of course, the curious thing is that it wasn't him. It's not this lawyer. This lawyer wasn't involved at the trial level. So it wasn't up to this appellate lawyer whether or not these issues were raised with the trial court at the time. That was up to the defense lawyer at the trial. So two different people making different sets of decisions. But this guy is bound, this appellate lawyer is bound by the decisions made or not made by the trial defense attorney.
I believe the one was raised also with the police department, but I don't have the exact citation with me right now to that.
But he had been, juror 52 had been questioned extensively on those issues, including what he thought of Black Lives Matters, what he thought of Blue Lives Matters. So he had been thoroughly questioned on those issues, correct?
He had been questioned by counsel on the issues.
And answered very straightforward that he thought Black Lives Matters was important.
That's correct.
That Black and racially and ethnically diverse people were not necessarily treated fairly by the police. He thought that Blue Lives Matters was a response to the Black Lives Matter. So he seemed pretty forthright on all those issues. So why, I'm having a hard time understanding how he was not forthright at all in terms of answering any of the questions.
Because if he would have revealed the issues about the march, rally, protest in Washington, it would have prompted other questions from counsel.
which goes back to, isn't it council's duty to ferret out those questions and ask those probing questions?
And what I would say, you're kind of identifying a chicken egg thing. And I think if jurors are not fully forthright in the juror questionnaire, then it's not possible for counsel to know to inquire into those areas in any depth.
Which goes back to the standard of review that we have, which is very deferential. We're only an error correcting court. And we give great deference to the district court's discretion, which here is very broad, to deny it, even if there are reasons, if there is an opportunity by the defendant to ask those questions.
Yes.
Okay, thank you.
So I want to get back to the, obviously, to the pretrial publicity and pressure on the courthouse issue. As we laid out in our papers, the court's to engage in a two-stage analysis or two-tier analysis regarding changing venue. And under the first tier, the court's to determine from the totality of the circumstances whether or not the pretrial publicity or any other factors are such that prejudice is presumed in the jury pool in the community where the case is going to be tried. And then after clearing that issue, you go to the second issue, which is to determine whether or not there was any actual prejudice. Our primary argument here is that this case could not be tried in Minneapolis because of the pretrial publicity, which was pervasive.
Yeah, so that's always been my position, that if you can't provide an impartial jury, not subject to coercion, in wherever the jurisdiction is that you would normally have the case, you need to move it to a different place where you can pick a different jury that's not subject to those kinds of coercive pressures. And if there is no jurisdiction within the state in which you could provide an impartial jury, because that's what the trial judge said here. When he denied a change in venue, he basically said, look, the publicity around this is worldwide. There's no place in Minnesota where we could try this case and the jury would not be subject to this kind of coercive pressure. And the trial judge was probably right in that assessment. My position would be, if you're incapable, period, of providing an impartial jury, you can't try that defendant because you can't give him a fair trial.
From Memorial Day onward through the trial, and also just the physical pressure on the courthouse. I've laid out in our brief the amount of concerns that the jurors had for their safety. That was all articulated to the judge during voir dire. In fact, Judge Cale acknowledged a number of times on the record that all the jurors had expressed concerns regarding their own safety. With regard to the trial itself, I believe it was 5 days before closing arguments, the governor ordered the deployment of the National Guard throughout the city. And that deployment again was ordered because of the upcoming verdict and the concern that if there was an acquittal, there could be riots again. And under the case law that we've cited, I think what makes this case really unique is again the riots that occurred.
And by the way, folks, I don't have any personal investment in Derek Chauvin. He's not a friend of mine. He's not a family member. It doesn't mean anything to me if he spends the rest of his life in jail. But I care. So I don't care particularly about the outcome in the case. I care a lot about the process. I care about due process of law, because if Derek Chauvin can be denied due process of law in a fair trial, that can happen to any of us. And some of us I do care about.
Because there's a few cases, we cited two in our briefing to the court, where you had courts either order a change of venue in the Lozano case or in the Nevers case, which was a habeas petition. The court released a police officer who was tried regarding an incident that occurred in Detroit, where the court laid out that the court put it bracing for a riot, and that you can't hold a trial in a community where the jurors are looking at the possibility of a riot in the event that the jurors would acquit the defendant.
Has the Minnesota appellate court ever in Minnesota ordered a new trial based upon presumptive prejudicial retrial publicity?
I couldn't find a case that did, Your Honor. And the state has argued extensively in the response brief that this two-tiered analysis I've laid out under federal law, under the federal Constitution, somehow doesn't hold in Minnesota. I was very concerned about that issue being raised here today, and in preparing for oral argument, I got onto Westlaw and went searching around for what I could find, and there was a treatise, criminal practice manual. It's called Standard Criminal Practice Manual. At section 33.3 discusses this presumption of prejudice issue, and the treatise.
So a treatise, folks, is just a fancy word for a legal textbook where experts have surveyed the law generally, maybe not just in one state, and have written in depth about the legal doctrines involved in a certain area of the law. It's not uncommon. So within a state, the case law is created by the appellate courts, by the mid-level appellate courts and the state Supreme Court. And that's called case law. That's just as valid law as a statute that's passed by the legislature and signed by a governor. The case law of another state, a different state, is not controlling in the first state, right? So here we have Minnesota. The case law from Michigan would not be controlling in Minnesota. And it's not unusual for the case law in one particular state to never have touched on an unusual legal doctrine. So that state could have no case law on that particular issue. But it can be informative to look at other states and find appellate court decisions in those other states that do touch upon that legal issue and share those decisions with the court. It's not controlling on this appellate court, case law from another state, but it can be informative. The same thing with treatises, these legal textbooks that survey the law generally. Expert legal scholars develop these things. They're not controlling law. They're not statutes. They're not case law. They don't control what this appellate court panel would be allowed to do, but they should inform the panel in the absence of their own existing case law.
Treatise said, some courts have suggested that the moving party bears the burden of demonstrating actual prejudice by adverse publicity, and then it cites, for example, State v. Wazaco, 269 Northwest 2nd, 373 Minnesota, 1978. The treatise then continues by stating, although the viability of this view is questionable in light of the decisions by the U.S. Supreme Court in Estes v. Texas and Shepard v. Maxwell. My argument here is I would agree with you. From looking at the Minnesota decisions, they seem to imply that even if you have this presumption of prejudice under the federal Constitution, that there's still a requirement to prove actual prejudice. And that's just contrary to the federal court decisions. I'm sorry?
Don't those federal court decisions discuss the carnival atmosphere?
They do, because
When I look at the record here, I'm not observing that kind of quote, carnival atmosphere.
the test under those cases is a totality of the circumstances. So the one case you're describing was the Shepard case where there was a carnival atmosphere. The courts were, for instance, the four factors that were discussed in Skilling were non-exclusive factors. The distinction in this case is there's no other.
I mean, we had arson and looting already. There's a reason the National Guard was called out. So they're pretending that, I don't know, this coercive pressure didn't exist at the time. That's not credible.
Case I've seen where there have been the riots such as we had in Minneapolis prior to the trial of this case, coupled with the extensive security at the courthouse. I've got a red light on.
Yes, and you will have 5 minutes for rebuttal.
Thank you.
Thank you, counsel. Counsel for respondent, you also will have 15 minutes for your arguments. Please state your name for the record and the party you are representing, and you may begin when you are ready.
Thank you, Judge Reyes, and may it please the court, Neil Katyal for the state of Minnesota. The evidence at trial showed that on May 25th, 2020, George Floyd died at the hands of 4 police officers. Defendant Derek Chauvin pressed his knees into Floyd's neck and back. Another officer knelt on Floyd's back and held his handcuffed arms. A third restrained his legs. And a fourth held back onlookers who begged the officers to stop. Together, they pushed Floyd down onto the unyielding pavement for 9 minutes and 29 seconds. 9 minutes, 29 seconds. During the first minutes, Floyd pled with Chauvin, saying over 25 times, "I can't breathe." At no point did Chauvin provide Floyd any medical care, even after Floyd stopped breathing and moving, and even after Officer King told Chauvin that Floyd didn't have a pulse.
When did he tell him that, counsel?
Excuse me?
When did he tell him that?
In the course of the events, it's about, I think, about 5 to 6 minutes in.
No, that's not true. So that statement was made. All the Officer King said was, I checked him for a pulse. He never said he has no pulse. And in any case, there's no indication that Chauvin ever heard that statement. Chauvin never responded to that verbalization.
Okay,
And
thank you.
still, no medical assistance was rendered. What followed, Your Honor, was one of the most
Of course, medical assistance had already been called for. They were waiting for EMS to arrive.
transparent and thorough trials in our nation's history. The court and parties painstakingly selected a jury over 2 weeks. 44 witnesses testified. Jurors watched video footage and heard from bystanders.
By the way, those 44 witnesses, I objected at the time. I thought it was highly objectionable, cumulative evidence. They had everybody who stood on that sidewalk testify to essentially the same facts. That's the definition of cumulative evidence that has a prejudicial effect.
They learned Chauvin was trained against prone restraints because of positional asphyxia, which is the very thing that killed Floyd. And the jury found Floyd guilty on all counts. Now, Chauvin's many arguments.
So we can, this guy's arguing that we know the positional asphyxia killed Floyd. Do we know that? Really? Or was it the knee on the neck that killed Floyd? Or was it the fentanyl that killed Floyd? Or was it Floyd's existing heart condition? Or was it the fact that he viciously fought arrest for 10 minutes before he ever went to the ground? But here's the problem, folks. Those are all arguments you make at trial. But once you're convicted at trial, you're presumed to be guilty. You were found guilty by the jury. And the appellate court is going to look at the evidence in the light most consistent with that conviction, meaning with the prosecution's narrative of guilt.
Before this court do not come close to justifying reversal. There was no abuse of discretion nor actual prejudice, and to the contrary, Judge Cahill managed this trial with enormous care. And even if Chauvin could identify some minor fault, any error is harmless. The evidence of Chauvin's guilt was captured on video for the world to see. I'd like to start with where the court did the Schwartz hearing. Now, I acknowledge my opponent said that that wasn't the primary issue before the court, but since it's where the court started, I'd like to make 5 points about it. First, Chauvin forfeited this argument before this court and before the district court, and he has to run the table on forfeiture because we're going to be in the land of abuse of discretion, as Your Honor was saying, and indeed plain error review. In the context of Schwartz hearings, he has a special obligation to raise this at the earliest opportunity. And as Judge Reyes, you pointed out, Chauvin had an opportunity to question Juror 52 during voir dire. Indeed, an extensive opportunity. The transcript reveals 35 pages of questions to Juror 52 during the voir dire, a very extensive process. And as Judge Reyes, you were saying, it's not as if Juror 52 was some sort of closeted Trojan horse that was, designed to, trying to hide his views. He was as forthright as possible, time and again, about his views that he had seen police brutality. He believed that the police department discriminated, and that he thought this was a historic case and wanted to be on it. At the same time, he also said he could render an impartial verdict that some of his friends were police officers and law enforcement officers, and the defense made the strategic choice not to strike him. Indeed, they were left with 3 strikes at the end, 3 unused peremptories. Judge Cahill gave 18 peremptories to the defense. Normally, he'd be entitled to 5. 3 of them were left unused.
So this is funny. So of course, the judge did give a lot of peremptories to the defense and to the state. Peremptory strike. So a peremptory strike is where if you're doing voir dire, you're doing what's mistakenly called the jury selection process. We don't really get to select a jury. We have a modest ability to deselect individual jurors. But every time you deselect a juror, you don't know if the next juror in line that you're going to be questioning is even worse than the person you're deselecting. And ways to deselect a juror are either for cause, they express some kind of bias, for example, or they're related to a party, or there's various for cause reasons. Or if you can't point to a specific cause, you have a certain limited number of peremptory strikes. You can strike them for really no reason at all, as long as it's not racially motivated. There's certain restrictions on it, but basically it's free strikes. Peremptory strikes are you can just get rid of the person without having to give a particular reason. And normally they would have had 5, the defense. They had 18. But why did they have 18? Because of all the pretrial publicity and the rioting and looting and arson and protests and marches that tainted the jury pool. That's why they had so many.
Used. The Warren case says that's a very good indicia that they were satisfied with the claims made with juror 52. Now, my friend said, my opponent says that he made many of these claims before the district court, but Judge Reyes, you're absolutely right. The claim that was made before the district court for as to why juror 52 lied was a claim about whether he had attended any protests in Minneapolis. And obviously, there's no evidence that he did. And that's why I think Judge Cahill denied the Schwartz hearing. So that's the first point. The second is, I think my opponent ignores the procedural posture here. The question is not, would a Schwartz hearing have been a good idea or something like that? You're not independently asking that. You're rather asking the question on appeal, which is, was it an abuse of discretion not to have the Schwartz hearing? And there is deference, very strong deference, given to the trial court. That is what.
Yeah, so this is the point I raised at the start of this, right? If it's just a judgment call by the judge and the Court of Appeals thinks, well, if we were making that decision, we would have made it differently, that's not going anywhere because they grant the trial court the discretion to make those judgment calls. They're not going to second guess every decision by the trial judge. So it's not whether they think that was the right decision. The question is, could a reasonable judge go that way? Even if they disagree with that choice, could a reasonable judge go that way? Or was it insane to make that decision? Unless it's insane, completely irrational, or in violation of law, the chances of them calling an abuse of discretion by the trial judge is virtually zero.
What the Benedict case says, and as well, Your Honor, Judge Reyes, what you were pointing out, the Stofel case says that as well. The third thing is that I think my opponent's brief misstates the law about larceny because they quote one sentence from larceny, which says that they can make a prima facie case, but then it goes on to say that the state can rebut that prima facie case, and only if a juror has quote necessarily lied do you get a Schwartz hearing. And with respect to the question that they are isolating, was there a protest in Minneapolis that you attended? There's no claim that he necessarily lied. And most, I think, the evidence shows an honest mistake. I mean, Juror 52 wasn't trying to hide the ball or anything like that. He was very clear about his views of police brutality and racism, as I said. And the standard for a Schwartz hearing is that he had to have necessarily lied, which I don't think they come close to doing. And it's also important to remember that Juror 52's own explanations in the media stories that they point to explain he didn't lie. The Juror 52 said, quote, it was 100% not a march for Floyd, that it was the 57th anniversary of the MLK anniversary. He said he, quote, did not attend the protest on behalf of George Floyd. When asked whether this could be interpreted as a protest related to Floyd, he said, not even close, not even close.
And, Counsel, you would acknowledge, though, that there were people who were discussing, advocating, and speaking on the death of George Floyd and this particular case here, correct?
Sure, Your Honor, absolutely. But I don't think that makes it a necessary lie. And I think the reason why that question is on the questionnaire, which is formulated with input from both sides, is because you're trying to ferret out someone's attitudes as a juror. Are you trying to see, do they have some sort of bias or predisposition to rule a certain way? And here, Juror 52 was as forthright as one could imagine. If you look at our brief at page 27, it recounts the statements made during the voir dire as well as in the questionnaire, all about how he thinks the police are abusive and so on. But what he also says, and he's asked 7 times about this, can you render an impartial verdict? And he says yes. And indeed, one of the questions by my adversary is to Juror 52 is, well, what about all these protests? Can you still render a fair verdict? And he says, absolutely. The protests are very different things than the facts of this specific case. So they've made a strategic choice to leave Juror 52 on at a point when they still have unused peremptories. And I don't think now they can bait and switch and say, well, we got it wrong, and, Juror 52, we should have a Schwartz hearing. As Judge Reyes, your first question to my adversary was, you had the opportunity at voir dire to follow up, particularly when you have these extensive answers that say he believes the police are racist, he's seen incidences of police abuse and the like.
Assuming we might disagree with you, how do you propose that we would handle the?
So just an observation here, folks, but of course there's a number of issues that Chauvin's appealing on, a number of arguments he's making why he should have a new trial or why this Schwartz hearing should have happened. And not all the arguments are going to be equally compelling, right? Some arguments are going to be stronger. You start with your strongest argument on appeal, and then you say, but if you don't buy that one, here's my next best argument, my next best. And your arguments get relatively weaker and weaker because you started with your strong one. Here, what this Court of Appeals did was when the defense was up, when the appellant was up and was beginning his oral argument, they said, hey, before you jump into your strongest argument, can we burn through 12 minutes of your 15 minutes of time talking about your least compelling argument? And now the state is here also starting by addressing the least compelling argument for appeal and burning through their 15 minutes talking about that argument.
A remand for a Schwartz hearing.
Yeah, I think you would remand for only the Schwartz hearing and nothing else. I'd caution the court very strongly against that, because if you do that here, then you're going to have it in every high-profile case. Remember, Your Honor, the Minnesota Supreme Court in the Larson case said that you have to be careful about accusations against jurors, and this was before an age of social media. I mean, if what they've done here, this kind of sandbagging is permitted, in every high-profile case, the defense, after a guilty verdict, will scrutinize the juror's Twitter, Facebook, social media.
I appreciate that argument. My query is more to what do we do with the rest of the issues on appeal?
Yeah, so I think you wouldn't necessarily have to decide them. I think you could just remand for the Schwartz hearing and leave those to another day. We do think the other issues are so clear, you might as well just decide them now. I'm happy to turn to the other issue he focused on, venue, but I'm also happy to answer any other Schwartz questions first.
I actually have a different question on the cumulative testimony. 7 witnesses testify. Why isn't that piling on? Why isn't that considered cumulative?
Well, I think the judge has massive discretion there. And as we say, the State versus Bobo case says that for the central issues in a case, there isn't any such thing as cumulative testimony. And here, reasonable use of force was the central issue in the case.
I'm sorry, can you state that again in terms of what case are you talking about?
State versus Bobo, it is cited in our brief, Your Honor. It's a Minnesota Supreme Court case, and it basically says, for central issues, there's a different standard for what is cumulative and what isn't. We also don't think that it would be reversible error under any circumstance, because cumulative just simply means that's more additional evidence. There's no case that says you would reverse or something because of the presentation of cumulative testimony. And that's particularly so here because each of the 7 witnesses testified from a different perspective. And remember, the defense was trying to pick off each of these witnesses, attacking them. They said, for example, Chief Arredondo was just a desk officer, an administrator. He hadn't been in the field. And they said, another witness was a national standards expert and wasn't relevant, even though this court's decision in Noor permitted it. So they were trying to attack each one of these, and that's why we as the state did present a comprehensive picture to the jury of this central issue in the case.
Well, you also argued in your brief that you thought that any effect of it would be cumulative. Any cumulative effect would be harmless. And you cited the McDonald-Richards case, but I'm not sure I read that case the same way that you do. I don't think it analyzed whether evidence was objected to as cumulative, but whether the error was inadmissible as an inadmissible statement was harmless because it was cumulative of other evidence. That's a different standard than what we have here.
We quite agree with that, Your Honor. I think our point is that Rule 403's prohibition on cumulative testimony, it's really about efficiency concerns, and there aren't cases that say that you reverse because of the presentation of cumulative evidence. And we'd also point out here that Judge Cahill was very solicitous of the concerns about cumulative testimony and indeed restricted our ability to use these witnesses because of that concern. So I think what Judge Cahill did was absolutely in the heartland of what trial court discretion is all about. You'd really have to find an abuse of discretion for the first time on cumulative testimony. And here, again, each of the witnesses testified for a distinct perspective and in a circumstance in which the defense was trying to pick off each of the different witnesses, saying that they weren't qualified or something like that, and so that's why we decided to present that full picture to the jury on that central issue.
Counsel, appellant cites to a lot of the case law related to having too many expert witnesses. Could you clarify for me how many of these witnesses were called as expert witnesses and how many were called as fact witnesses?
I believe that there were 7 witnesses called. In the one case that they cite, Deshay, I don't think comes close to saying what they are saying. That was about a gang witness that was testifying, and indeed at page 888, the court says that that expert testimony, quote, may add precision or depth to the jury's ability to reach conclusions about matters that are not within their experience. And indeed, the bottom line of Deshay is very much supportive of our position. If I could just say a few words about venue, because that is our argument that my friends wanted to start with. And I'd say 5 things. First is that they don't meet the standard, as Judge Reyes, you were suggesting, of clear abuse of discretion and actual prejudice. Presumed prejudice has almost never happened. Your Honor, as you were saying, the one example is Shepard. And in Shepard, what the U.S. Supreme Court said is even in that Bedlam proceeding, if a trial judge managed it correctly through voir dire and through instructions to the jury, even with that Bedlam, that would have been permissible. Here, the district court used extensive procedures for a fair trial, the jury questionnaires, individual voir dire lasting 2 weeks. The Skilling case, the U.S. Supreme Court held it with a 5-hour voir dire in a far more carnival-like atmosphere than the one that was going on in this case. There were 18 strikes given to them. The Warren case says, on venue challenges, if you have unused strikes left at the end, that's very good indicia that the defense was happy with the jury. And most importantly, they never deal with what we say at page 16 of our brief and the 3 Minnesota Supreme Court cases, Blum and Parker and Thompson, which say the relevant question is not, was there kind of security concern or pretrial publicity in one area? If that pretrial publicity was going to blanket the state, then there is no advantage to shifting venue. And here, Judge Cahill specifically answered what you heard today about the security concerns and the barbed wire and the like. What he said is, and this is quoted in our brief at page 16, that having the trial at the Hennepin County Government Center would be safer and reassure the jury and make them more impartial, not less, because the security could be folded into a general security over the city. And even if you had trial in some other place in Minnesota in a smaller venue, he said the security would stand out and you'd have the same fears of civil unrest there. And so he's made all of those findings on the record at document 192 at pages 4 to 5.
Counsel, I have one more question that I'd like you to address briefly, and that is whether a police officer can be convicted of a second-degree felony murder involving the predicate felony of third-degree assault, and discuss reasonable force as well as whether or not that creates a strict liability, which is, I believe, appellant's argument.
Yes, absolutely. So that argument will be reviewed on plain error. It's not an argument that they made below. And we think that that kind of 007 license to kill idea is absurd, because even if you spotted everything in their legal argument about how police officers generally could be guilty of felony murder, here Chauvin acted with special danger to the individual. The jury found.
The special danger, I mean, that goes to appellant's argument, though, that there should have been a jury instruction, which the district court denied. Are you saying that the district court did abuse its discretion then by denying the request for special danger jury instruction?
No, the district court did everything right. There's no need for an instruction because the Minnesota Supreme Court on 2 different occasions in the Anderson case and in the Cole case have said that when it's a crime against the person, you don't need any sort of special danger instruction. Your Honor, what I was saying was you don't even need to get there as to the question of whether there's a special danger instruction that was required or not, because here the jury necessarily found that in finding the second-degree manslaughter conviction of Chauvin. And so there's case after case that says that when there's an assault, that is a predicate felony for the felony murder doctrine. And my opponent's argument on the other side is to say, well, that'll be a strict liability offense for police officers. That is absolutely wrong. Unreasonable use of force is always required. That's always the safeguard against this. And, if anything, the Graham standard, which has been incorporated into Minnesota law, has been criticized as being too friendly to police officers. But here, that's what the jury was instructed on. The jury absolutely found that under that standard, Derek Chauvin acted with unreasonable force, 9 minutes and 29 seconds on George Floyd's neck.
That's just a lie.
Judge Claflin?
And anyone who watches the video can see that it's on portions. Most of that interaction, in fact, the knee was between the shoulder blades, not on George Floyd's neck. So that's just nonsense. And by the way, no injury to George Floyd's neck at all. So how much pressure was being applied for 9 minutes? Nonsense.
Thank you, counsel. Counsel for appellant, you will have 5 minutes for rebuttal.
I want to start off the rebuttal by dealing with the second-degree murder charge. Nobody is suggesting that there's any 007 thing. The problem with using the felony murder rule under the second-degree murder statute is there's no intent. There's no intent instruction.
Well, there's an intent instruction. There's a general intent instruction because you have the assault. That's a general intent offense.
Fair enough. I'm sorry. The problem with a police officer, the intent instruction for assault, and I don't want to waste a lot of time on this, is the intent to touch. Minnesota Supreme Court has held it's not the intent to injure somebody. And the problem with a police officer when they are arresting somebody is they have to touch them. So you basically eliminate the intent.
Right, but you still have the reasonable standard, and that's under the statutes as well.
That's correct, but that's an objective standard. I mean, it's unusual to have a murder charge with no finding by or no instruction of the jury of any kind of subjective intent of the defendant. That's the argument we were making.
Right, it is an objective standard, but I think I understand your argument to be a strict liability. It creates a strict liability for police officers.
Yes.
But the Dorn case seems to undercut that argument, doesn't it?
I disagree with that analysis because of the way the felony murder statute is set up in Minnesota on assault. As we've laid out in our papers, Minnesota is a minority of jurisdictions where assault, most states do not allow felony murder where the predicate felony is an assault.
Right. And I understand that argument, but we're an error correcting court. If that is going to change, that has to be changed by the Minnesota Supreme Court or the legislature. That's not for us to change that.
And I made that clear in my brief.
Okay.
I said that in my brief. I just don't want to get up to the Minnesota Supreme Court and say, why didn't you raise this below? You waived it.
Fair
I
enough.
made it clear in my brief that you're bound by that precedent.
Okay. Fair enough, counsel.
So the reason, just to clarify here, felony murder, of course, is where you're committing some felony and a death results in the course of the felony. And the classic example would be you're committing an armed robbery. And there's so you have a gun on the clerk saying, "Give me the money in the register." And there's an armed citizen in the convenience store. Also, he pulls his licensed gun, fires a shot at you, misses you, the armed robber, hits an innocent bystander, kills them unintentionally. You could be on the hook for felony murder. You never had the intent to murder anyone, but someone died in the course as a result of the felony you were committing. So you can be on the hook for that death, even though you didn't actually kill the person or have any intent to kill that person. But the underlying felony for felony murder generally can't be the physical act that killed itself. It needs to be something independent of the physical act that killed. Otherwise, you're applying the same act for two criminal convictions. So here they're claiming the argument is the assault. In most states, assault cannot be the predicate felony. Aggravated assault, felony assault cannot be the predicate felony for felony murder because it's the same act. It's the assault that killed. It's either has to count for aggravated assault or it has to count for murder. It can't count for felony, aggravated assault by itself or murder by itself. It can't act as the underlying felony predicate for felony murder in most states, but Minnesota says it can.
I want to get back to the venue issue. I want to make a couple of points with it regarding to the presumption of prejudice. Number one, it's not subject to any kind of abuse of discretion standard. That is a de novo review. I spent quite a bit of time reading the Skilling case, and one of the things I've done in my career, which may sound a little bit odd, at times I've used statements by the dissents in cases because the dissent sometimes will more accurately or concisely convey what the majority did. So in the Skilling case, Justice Sotomayor wrote the dissent. She made very clear in the dissent that
Sotomayor dissent. Sotomayor is an idiot. So she writes a lot of very stupid dissents. And apparently he's citing her dissent not for the value of anything she's arguing, but for her summary of what the majority opinion, the correct opinion was. That's rich.
There's this presumption of prejudice standard that you have to go through first. But one of the quotes I wanted to cite from her dissent was, she stated, as I cited earlier, the Estes and Shepard cases. This is the quote from the case. Estes and Shepard thus applied Rideau's, another Supreme Court case, insight that in particularly extreme circumstances, even the most rigorous voir dire cannot suffice to dispel the reasonable likelihood of jury bias. That analysis shows that this has to be a de novo standard. In other words, the pervasiveness of the publicity, and in this particular case, combined with the physical threats in the courthouse, provide an environment that the Supreme Court has held. You can't trust the voir dire at that point.
Why does it have to be a de novo standard? Why can't it still be an abuse of discretion of whether the district court abuses discretion by continuing to hold the trial in that venue, or not allowing a continuance, or not sequestering the jury? It seems like those are all under the abuse of discretion standard, aren't they?
Typically, abuse of discretion applies when a trial judge is evaluating some kind of testimony and weighing.
Well, it's more than that. It's also for evidentiary hearings, issues, as well as basically trial management.
Correct. I understand that.
And a motion to transfer venue, sorry.
I'm sorry, we were both talking.
Yeah.
Go ahead.
Yeah.
Go ahead.
And a motion to transfer venue, that's up to the discretion of the district court as to whether or not to grant that motion.
Not under the first tier that I laid out. I'm getting really short on time. One factor I want,
That's okay. And just to let you know, if you need a little bit more time to answer this question, that's fine.
thank you. I'm sorry, do I have a question pending?
Yeah, here's my I see where you're coming from, but I think isn't the overarching standard of review abuse of discretion, but a district court can abuse its discretion if it applies the law erroneously. So I see your argument in terms of whether or not the district court appropriately applied the law, but isn't that under the abuse of discretion standard?
No, it's de novo. And the reason I laid out the quote from the Skilling case was the trial court's judge's analysis of voir dire is subject to abuse of discretion because the judge is watching the jurors and the like. As Justice Sotomayor laid out in the dissent, coming from the majority opinion, the Rideau case, there are some cases that are so extreme that even rigorous voir dire is not going to overcome a juror's bias. That to me reflects the fact that it has to be a de novo standard because the jury voir dire doesn't matter. Before I end, the one last thing I wanted to say, and I wanted to say this at the beginning, makes it very unique, is Mr. Keitel laid out that no matter where this case got moved, it wouldn't matter because people would know about it and the like. The difference here is the jurors that sat on this jury had a stake in the outcome of the case because they lived here where the riots occurred. If this case gets moved out state, the likelihood of having riots in the community where the jurors are living, I believe, will be zero. Thank you.
Judge Larson, Judge Klapek, any other questions? We ran a little bit over, but I want to make sure that you had the opportunity to answer the question fully. So thank you very much.
Thank you, Your Honor.
Counsel for both parties, thank you very much for the briefing. It was very extensive, very thorough, and we appreciate that.
And that is that. That is that. So I'm going to take a look at questions. Before I do, just a reminder to everybody, we have our law self-defense advanced class taking place on Saturday, April 15th. We only teach this class once or twice a year. It's a full day live class taught by me personally, plain English self-defense law, cover really every facet of it. It's applicable to all 50 states, doesn't matter where you live. And if you sign up for this Saturday, April 15th course today, or this month, it's 50% off the normal registration. Save yourself $100. If you sign up for it in February, it's only 25% off. In March, it's only 10% off. In April, it's just the full price. So I would encourage you to click over to this URL here, learn more about the class, take advantage of this 50% off opportunity at lawofselfdefense.com/advanced. All right, let me take a look at questions. Let's see. Let's see. Law self-defense member Tax Pro Pam says, question not related to this hearing. Can I send a proposed bill for self-defense law to get your opinion? Sure. I would suggest you send it to support at Law Self-Defense and put in the subject line, forward to Andrew or something along those lines to make sure it's brought to my attention. Let's see. Okay. Let's see. Didn't that juror's March participation come out well into a trial? Well, after voir dire? Well, yeah, it didn't come out until I think after the verdict was rendered. Unfortunately, folks, this is one of the reasons that these defense legal costs get so big. During the George Zimmerman trial, there were people trying to sneak onto the jury, going through voir dire, prospective jurors who had Facebook pages advocating that George Zimmerman be lynched. And during voir dire, they'd lie. They would just lie during jury questioning and say, no, I'm impartial. I'm not biased. I don't have any preconceived notions about what the verdict should be in this case. But the defense team for Zimmerman was large enough, not just the two lawyers we saw in the courtroom, not just Don Smith and Mark O'Mara. It was big enough, they had enough other staff on this case that they were able to do a thorough search of the social media of every prospective juror and disclose this evidence of bias during the jury selection process, get that juror stricken for cause rather than use one of their rare peremptory strikes to get rid of that juror. But that takes a lot of resources to do. And that's one of the reasons these trials get expensive. Here, we really only had the one defense attorney for Derek Chauvin. Okay, so that, I think, is all the questions from the members. And let me take a look here, see if we have any super chats that need to be addressed. I saw at least one come in. Let's see. Yes, Warren Lee, $10 super chat. Thank you very much. Says the Greenwood, Indiana police have completed their investigation but are not releasing the video of Eli Dickens' response. Would you do a Freedom of Information Act on the video and present your analysis? So this is that mall shooting where some lunatic came into the mall with a rifle, shot 3 people dead, surely would have shot more people dead, active shooter scenario, except Eli Dickens happened to also be in the food court area, had his concealed carry pistol on him, fired, I think he fired 10 rounds at the active shooter with his handgun from 45 yards away, and hit 8 times, mortally wounding the attacker, immediately stopping the fight. I mean, there's no legal ambiguity there about the justification for Eli Dickens shooting the active shooter. It's a clear-cut defense of self, defense of others scenario. So, I mean, it's a fantastic outcome, tragic that 3 people had to die first, of course, but that's the only way you know that an active shooter event is taking place. Tragic in that sense, amazingly positive in the sense that it wasn't 30 people killed, that Eli Dickens was there and capable of effectively responding to that shooter. But there's not much to talk about from a legal perspective. If the video were to become available, I guess I would cover it, but I'm probably not going to bother with the rigmarole of filing a Freedom of Information Act with the police department to release the video. Sorry about that. All right, folks, I think, we got the fire department going off in the background. Can you hear it? They're not coming for me, folks. I'm safe. Only another year and a half in this office before I can move out, get away from the train, get away from the sirens. All right, folks, remember, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill. So my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.